Very good afternoon to all. Am I audible, please? I am
Yes,
audible.
ma'am.
Yes.
Yes,
Good
ma'am.
afternoon, everyone. Respected Chancellor of the University, Pro Chancellor, Vice Chancellor, ma'am, all the directors. Special thanks to Dr. A.K. Paul, sir, and the resource person of the day, Dr. Sandeep ji. I thank all the faculty members and the students who are present over here. As you know that we are celebrating World IPR Day, and this week is being celebrated from 26th to 30th all over as World Intellectual Property Right Day. So in the same series, Desh Bhagat University has also taken an initiative for the same, and our thanks are to Dr. A.K. Paul sir, who has helped us in doing this series. I am thankful to the patent cell of the university as well as IDC. Before I am not going much into the details, just want to share with you that Dr. Sandeep Singh is the resource person. He is principal scientist and IPR coordinator, CSIR, CSIO, Chandigarh. He is working in CSIR since 2004, and his areas of research are optical devices and system research. He has been working on IPR since 2012. He has been awarded with number of awards in various spheres as Fellow IETI Honorary Secretary CSI Chandigarh Chapter, WIPO Fellowship for International and Distance Courses, PGTI PR, WIPO Certificates, National Merit Scholarships, and many more. Sir has much more to be added in his profile, but I will hand over the things to Sir. He will be expressing and guiding you everything regarding IPR, creative expressions, and innovations. I thank Sir for sparing your valuable time, and it's my request to all the students, kindly mute your mic and off your cameras. Nobody's camera should be on. So mute your phones as well as your cameras. I request Sir to kindly start with the session. Thank you, Sir. Thank you so much.
Thank you very much, ma'am. I have some last minute glitch in my camera, so I would not be visible, but I think my voice is clearly visible.
Voice is visible. No issue, Sir. No issue. No issue.
I am audible, huh? Okay.
Yeah.
So if most of the participants, there are a lot of students in the participant list, as I can see. So I will basically present a brief overview of what IPR is actually. The theme of this year's World IP Day is how can small businesses or SMEs leverage the intellectual property system to come up with a market advantage or become more competitive in the market. And since all these students are actually knowledge workers, in the coming time they are definitely going to join the industry and academia, wherein if they are attached or associated with this cause, they will definitely help the companies or organizations they work for in fostering better IP management, coming up with better facilities with regard to honoring of IP. And in this regard, before moving further, I want to thank you for inviting me for this event. I also want to thank Dr. Paul, who has been a mentor of mine at CSIO, for giving me this platform. Thank you very much, sir. So with your permission, can I start my presentation?
Sir, sure, sure, sure.
Thank you very much. Okay, are the slides visible to you all?
Yes, Sir, they are visible. They are
Okay.
visible. Before I starting, our Vice Chancellor ma'am has joined. I welcome ma'am also on this event. And in the end, ma'am would be sharing some views. So thank you, ma'am, for sparing your time.
Okay. Okay. So friends, what is actually intellectual property? Intellectual property is actually creations of human mind. So what do I mean by creations of human mind? Is that whatever is available in the nature as common. You have water, you have other energy resources, you have light, whole lot of things which nature has given you. But with the creative and inventive endeavors of human mind, we have come up with so many inventions, so many creative expressions, that today, in a way, from a survivor, human has become the ruler of this earth. And we are talking, we have reached the point that we have started talking primarily in terms of sustainability. We have started feeling that if we go at this pace, sustainability is going to be an issue for us. So in that context, intellectual property is basically an intangible property. It can be implemented into a physical form, but that knowledge, the knowledge portion of that form is intangible. And as any other property, like your car, land, this property is also being protected by the law of your country, by the sovereign government of the country, in the form of registrations. So you enjoy the same fun, same rights, same privileges as your car or building with the intellectual property. You can enjoy it, you forbid others from using it, you can lease it, you can rent it, you can do whatever you want. So in this context, I would like to today put some perspectives on why intellectual property is necessary. In fact, as if we will shed light from three perspectives. One, from the perspective of philosophy, why IP should be honored. Another, from the perspective of practice, and finally from the perspective of global trade laws, which has made IP a big thing as far as trade engagement between the countries is concerned. And then we will try to discuss some specific modalities of IP. As far as I read, this particular the organizers have some linking with agriculture, and so I have tried to inculcate plant varieties protection also in my presentation, which we will also discuss. At any point, if you have any doubt, I always feel good and happy that we interact, because interaction is what actually is an indicator that something has aroused in your mind. And if I am able to satisfy that arousal with the with my inputs, I will be very happy. So as a philosophy, why should we protect IPR? So IPR, the background of IPR is that if some knowledge is generated, so the society has an interest in that knowledge and dissemination, because it makes the life easy, it makes the life wonderful. Now, in return to that, the inventions, the inventors or others who have generated that knowledge, they basically want some recognition and reward for their creativity. And finally, the markets for knowledge and information are subject to failure. So, in light of these three perspectives, basically the IPR plays the role of a weighing machine. It tries to balance the advantages to the society as well as the advantages of individuals by providing certain form of IP for a limited period of time. And in that course, what happens is that knowledge is codified, and the codified knowledge becomes an asset for humankind for perpetuality. It does not die out. If we do not entertain or oblige the intellectual properties, it may happen that due to the fear of losing that recognition and reward, a person does not disclose it anywhere, and that knowledge dies out with him. This is somewhere what has happened with the ancient Indian knowledge, which we usually feel that it was very rich, but today we are dependent on other countries for the knowledge. We are receivers of knowledge as far as current scenario is concerned, if you go to the current literature of technology, you will find that India is seen as a technology receiver rather than a technology provider. Whereas at one point of time, we were leaders in the world. We gave philosophical warrants to the world. We are the only one or two countries in the world which has given a philosophical direction. 3, 4 religions have generated from India. And so in this context, as a philosophy, IPR is basically doing the balancing act between the interests of the society, interests of the individuals, and interest of the markets. As a background, if you see why IP has become important, so the global technological capabilities have basically increased manifold with the advent of telecommunications and internet. It has become the physical distances have vanished. We are very proximate to what is happening on a day-to-day basis in any corner of the world today. Again, reverse engineering is another aspect. It has become feasible in developing countries. This was the genesis why, again, it is always about balances. Why developed world is interested in having an IPR system, because they feel that they can have better control over the IP violations in developing countries like India. But developing countries like India are more uh, uh, benefited with the IP system because that access to knowledge has become easier. Rise of information and communication technologies and reducing copying and imitation cost. Previously, if you want to copy 10 songs, you had to buy a cassette, record it, and then that tape had a very limited life and a lot of issues. But today, GBs and GBs of data, generation as well as storage, it feels like it's a very trivial task, but it is a very recent thing. Mind me, in my student years, I am not very old as on date, but in my student years, a computer with a 64 MB RAM was a luxury. Usually we had 32 MB RAMs. So technical changes have made traditional concepts of IPR obsolete. Again, what happened is that a lot of new IPRs are emerging, some of which we will discuss today. And for copyrights and all those things, internet has changed the world a lot. So there are a lot of important things happening, and as a technical field also, IPR is witnessing a lot of changes. And this is how the entire background of the universe in which you live, I would call it a IP universe, and that IP universe has generated post 2005. I will go you through that chronology, what has happened post 2005. But for this moment, you understand that there is a new world in the field of IP that has been generated in India post 2005, and those technical changes have made the concepts of traditional IPRs obsolete for a matter. Now, the most important change which has come in the domain of IP came in 1995. You might be knowing that up to 1995, there was an international trading agreement called uh, GATT, General Agreement on Trade and Tariff. India became signatory of GATT in 1948, and in fact, GATT continued up to 1995. However, in 1995, GATT was replaced by WTO, World Trade Organization, and WTO was nothing but was GATT plus services plus TRIPS. So the service industry traditionally was a muted industry with a local reach, but after the IT came into emergence, service industry became a big thing. If I talk of some data, when in 1996 Dr. P. Chidambaram introduced the service tax, the first year he envisaged a revenue of just 2,000 crores. But you know what is the mix of revenue as on date? The majority of the revenue for the government comes from the service tax. It has even surpassed excise in many aspects. So the GATT was basically extended by WTO into 3 agreements. One was General Agreement on Trade, second was General Agreement on Services, and the third was TRIPS, Trade Related Aspects of Intellectual Property Rights. And this was the agreement which, in the first time of the history, basically tied IPR with the trade policy. So whichever country wants to be part of WTO had to be TRIPS compliant, and then the timeline for TRIPS compliance for developed countries was immediately from 1995. Countries like India, which are developing and emerging low income countries, got 10 years, and we had to be TRIPS compliant by 2005, and we became TRIPS compliant by 2005. And this is why I was saying that IPR as an arrangement or as a framework has seen a new universe after 2005 for countries like India. For underdeveloped countries, the timeline was 2015. However, it has further been extended up to 2030 because the infrastructure in those companies is not ready. So with this, strategic trade and industrial policy has joined hands. Strategic trade and industry policy has joined hands, and IPR has become an important part of the trading agreements, the trading saga, the trading domain, and so it has garnered a lot of attention. If I go into the history, I think you should know this. Pardon?
Yes, whosoever is the student, mute yourself.
Okay.
Sorry,
So,
sir. I will check it out.
Yeah, no issues, ma'am. Basically, if I go into the history of WIPO, World Intellectual Property Organization is a global agency. It is basically a specialized agency of United Nations, like UNESCO and ILO, and it works in the field of IPR. If we go into the genesis, it has two branches. One is the Paris Convention and other is the Bern Convention. Paris Convention was about industrial property. As we will follow through this presentation, we will see that IPR as a domain has two realms. One is the industrial property and the other is the artistic and literary works. So the Paris Convention was about industrial property. It was established in 1883, and similarly, as the printing press was invented, the printing press invention basically did a lot of harm to the royalties and income of the writers. So with the printing press coming into existence, the Bern Convention was formulated, which was basically about copyrights and related rights, or at a more group level, if you say, literary and artistic works. These two conventions merged to form an international bureau in 1893, which subsequently became World Intellectual Property Organization in 1967. With in 1974, it became a specialized agency of UN, and with the TRIPS agreement in 1996, the WIPO was integrated with WTO, and it came into the real realm of the business of the world. Now, we all are knowledge workers. Why I say us to be knowledge workers? Because we are either expected to generate new inventions, make new inventions, we do make new inventions, or on the other hand, we create new creative works. So these are basically intangible assets. And if I see from a broadest perspective of classifying what IPR is, so IPR is about two things. One is the protection of idea itself, and the other is the protection of expression of idea. And within the realm of protection of idea, a very good example is that if I come up with a new machine, so I have used the commons which are available in the nature, applied my mind, generated an extra utility, and came up with a machine. Now, how I can earn with that machine? I will earn from that machine if I use that machine or produce that machine using an industrial process and offer it in the market. Then only I can make machine. And if I can make money, and if I offer in the market, naturally I will think that if there is some protection, because I had that risk in mind, that if I offer in the market, other people might copy my idea. So if I get a protection in the form of some industrial property, it will be better to me. And the other aspect is expression of idea. You know, a lot of people have a poetic heart, so they usually on situations like rising of sun, on depressing situations like COVID scenario, they write poems, they write stories, they write songs, and so on. Now, expression of idea is a bit loose, right? Whereas protection of idea is very much legal, you need to have a lot of paperwork in the form of idea protection. But expression of idea is a very loose right, in the sense that since it does not give you the protection on the idea itself, it just gives you the protection on the expression of the idea. So the moment you create that expression, you are the rightful or wishful owner of that thing. However, it is better advised to get that work registered with the authorities in the form of copyrights and related rights. I will discuss in detail what do I mean by patent, what do I mean by trademark, what do I mean by copyright, and what do I mean by related rights. In fact, I will touch upon the entire panorama of various IPRs which are available. Ma'am, just request how much time I do have so that I can plan the presentation accordingly.
Uh, Sir, actually, we have 3 to 4 time, but
Okay.
if you feel convenient, you can add it. No issue.
Okay, so it's 3:25 now. I will try that. I would cover it by 4. So
Thank you.
this is the entire panorama of the various IPRs. You know, some of these IPRs were available in India since 1911. However, some of these IPRs were not available in India up to 2005. But with the TRIPS framework, basically what TRIPS has given all the world is they have given a framework. They have given a framework of laws which needs to be entertained in all those countries which are WTO members. And within that framework, we have to come up with rules and regulations for protection of those things. Now, every country in the world has, according to their local laws, established, implemented that framework. But I would add that although TRIPS framework is mandatory, exact nitty-gritties are allowed to be as per the national laws, because ultimately intellectual property, like any property, is a sovereign subject. Whatever right you get in IPR is given by the government of a particular country, and so the jurisdiction, the reach of those IPRs is limited to the territorial boundaries of that country. Okay, now we will discuss the various types of IPRs in short. Then we will discuss patents in detail, followed by short discussions about other IPRs. And then finally, I will discuss a bit about the IP practice at CSIO, followed by some interesting keywords which I usually see that the participants in a lecture are interested in. So first of all, a patent is about industrial property. If you can connect with me, whatever I have talked up till now. So patent is about industrial property. It is about protection on the idea itself. So patents are one of the most common tool for knowledge workers who work in the field of inventive things. And many of you might have taken patents in your inventions, and they are available for the disposal. Then you have trademarks. Trademark is basically the identity of a company. It is basically the connection or connectivity or the goodwill which a company enjoys with that trademark, and that it has actually earned during the course of the business. Now, for a shoe, you might not pay 200 rupees, but for a shoe with a particular logo, if you get them in 2000 rupees, you may feel that they are cheap. Now, what is the differentiation? The only differentiation is the IP associated with it. And the IP association, no doubt, gives you a tinge of quality, tinge of confidence, but ultimately that IP is entertained. Then you have industrial designs. Industrial designs are IPs which basically are in market. We buy a lot of things not by their utility but just by their looks. Bed sheets, shirts, umpteen things you buy just how they look. It is unimportant that how they function. It comes secondary. In lot of things, the look is very important. So for such things, industrial design protection is available. Then you have a trade secret. Trade secret is not exclusively protected in India, but it is protected under the common law. There is no specific act for trade secret. And what do I mean by trade secret is that I have some important knowledge which I am not sharing to anybody. But the catch is, although trade secret can be perpetual, but if once revealed, it becomes a public property. So during the course of the business, if you share your trade secret with your employees, which naturally you have to do, then you should sign proper contracts with them, so that in case they violate the non-disclosure agreements, you have the legal remedy for it. And the world's best known trade secret is the formula of Coca-Cola. It is not known to anybody. At a time, 4 people know part of it and they join it somehow, and it is kept till now. Second IP, another IP is copyright. So copyright is about expression of ideas, and associated with copyright is another right called related rights. The good example for copyright and related rights is that Javed Saab writes a song, so he has the copyright on the song, but then Lataji sings it, someone else give the music, someone else broadcast it, and they all have some sort of rights, and they are all covered under the realm related rights. Now geographical indications are basically collective rights. What do I mean by collective rights? Up till now, whatever rights I talked about belonged to individuals or entities, whereas geographical indications are given to those distinct things which have been which are hallmark or trademark of a particular geographical region, and that name has been earned by the people of that region over hundreds of years. This IP was basically promoted mostly by the wines and the spirits industry. You know, champagne is also a liquor made of, is also a wine made up of grapes. But which wine can be called champagne? Only that wine which is produced from the grapes having been produced in the Champagne region of France. Similarly, if you call a whiskey as a Scotch, it has something to do with the Scotland. So in India also, geographical rights as a collective rights is taking speed very fast, and if you go to any airport these days, you will find a GI shop which sells lot of products that has a GI tag, like Banarsi Sadi, Chanderi Sadi, Rasgulla, Laddu, blah 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 blah. Then since many of you might be from agricultural backgrounds, plant variety protection was not available in India up to 2005. However, for being TRIPS compliant, India came up with a sui generis, means if someone is from legal background, he might be knowing one of its kind, with a sui generis law for plant varieties protection and breeders' rights. So that act basically provides for registration of new varieties, essentially derived varieties and extant varieties, which are known already in the public domain. So these new plant varieties can be protected by the farmers. They have to go through a specific testing called DUS testing, thus testing, and once cleared, they get an exclusive right on the variety for 15 to 18 years, depending on whether it is a farm crop or it is a tree. Again, there are certain rights on which currently discussion is going on at the WIPO level, like innovations and creative expressions of indigenous and local communities. This we call as traditional knowledge and traditional cultural expressions. These traditional knowledge and traditional cultural expressions have been also been discussed at the platform of Convention of Biodiversity, and accordingly national biodiversity authorities and state biodiversity authorities has been established in the country, who look after that whether the biodiversity of a particular region is not unsolicitedly used or exposed, and if it is ongoing, so there are certain means and measures through which investments can be made in the capacity building of those areas. Another newer form of IP is layout design of semiconductor integrated circuits. With the advanced photography techniques, it has become possible that the ICs can be photographed, and then through reverse engineering they can be copied. So for this purpose, layout design of semiconductor integrated circuit act has been enforced, and the registrations of IC designs can be done under that act. Now, moving on to specific IPs, the first IP which we would like to discuss is patent. What is a patent? Many of you might be knowing a patent is basically an exclusive right over an idea. So if I go by the exact definition, a patent is a right granted to inventors to prevent unauthorized use of an invention. If you see this definition, you will never find that this right is to exercise. This right is about prevention, to prevent unauthorized use of an invention within a particular territory. As I told you, that any IP is a territorial IP within a particular territory for a limited time, and this does not guarantee the freedom to exploit the invention. What I mean by does not guarantee freedom to exploit the invention is that although you might get a patent for a particular aspect of something, but it does not necessarily mean that when you are practicing that aspect, you will not infringe the patent of others. And since you don't have the onus of applying your patent, you can also become an infringer of somebody who is not applying but keeping a watch. So in this sense, patent is a negative right. Patent is a negative right, and in this sense, patent is a negative right that it does not put onus on you to use it, but it allows you to bar others from using it. Secondly, patents are territorial. So if you get a patent in India, you won't have any force. You won't have any advantage in another country if you have not taken a local patent there, just as foreign patents has no force in this country. And for that matter, I usually say that patent databases are gold mine of information. If any budding entrepreneur wants to cater something to this huge market of 140 crores, and if he has a knack for finding inventions which are patentable around the world, the information regarding which is freely available on the internet through many patent databases, he can come up with umpteen products which has utility for the Indian market without investing a penny in R&D. So, and then a patent is granted for a limited time. It is 20 years from the date of application. A patent application process takes around 5 to 7 years from application to grant, but your 20 years period is fixed from the date you have applied. Okay. Finally, it is a positive right. In what light it is a positive right? It is a positive right restricted by previous patents. So if there are some previous patents in your domain, and if by application of your incremental knowledge you are infringing the patents of others, then you might be in some problem. You don't have that freedom to operate. A very good example is the invention of incandescent bulb by Thomas Alva Edison. Thomas Alva Edison invented only the tungsten filament. The tungsten filament which lasted long enough that the incandescent bulb became a commercial viable product. But to practice his invention, to have freedom to operate, Thomas Alva Edison had to take licenses from all the other pupils who had patents in other aspects of the incandescent bulb, and then only he was able to come up with a market product called incandescent bulb, and it became a huge success. Rest is history. Now, these are the requirements of patentability. One is the substantive requirement and other is the procedural requirement. What do I mean by substantive requirement is what is the substance which is being seen in a patent application. Whether a patent application has the technical substance ahead of the knowledge that is prevailing in the world. And the second is the procedural requirement, which means that whether certain forms have been filled, whether the philosophical aspect of patenting has been kept into mind. So the substantive requirements are that it should be a patentable subject matter. What is not a patentable subject matter is defined in certain chapters of the Act. Then it should be novel, it should be non-obvious, and it should have an industrial utility. Procedural requirements are enablement, definiteness, and best mode. In the subsequent slides, I will discuss those things. So, what are the patentable subject matters? It can be something which is to be manufactured, it can be a machine, it can be a composition of matter, it can be a process. What do I mean by novelty? Novelty is something which is not anticipated in the prior art. And here, remember, I have been telling again and again that the rights out of a patent you get are territorial. Your patent is valid only in the country where you have got the patent registration. But it does not mean that you are free to patent the knowledge which is already existing in other parts of the world. Means anything anywhere in the world, if a knowledge exists, it can't be patented in any country, even for that matter India, if it is available in US or anywhere in the world. And not only this key, it is about patents. It means any form of knowledge, and that any form of knowledge includes patents, publications, commercial products, brochures, whatever. It should not be anticipated in the prior art. From a thumb of rule point of view, if you ask me what novelty is, or if in an engineering or an instrumentation patent, what novelty means, so I would like to apprise you that whenever the patent examiner searches for novelty violations, he tries to find a single earlier document which completely or totally describes your invention. And if there is a single other document anywhere in the world that completely and totally describes your invention, that means your invention is not novel. Even if there is a delta difference, then it becomes novel, and that can be that passes the test of novelty. However, that does not mean that that would pass the test of inventive step. Finally, utility is to be minimally demonstrated. It doesn't mean that whatever you are patenting, you need to come up with a physical embodiment and then show its utility. No, you have to just project what the utility of the product would be. Now, the most tough cut nut to crack as far as having a patent is concerned is obviousness. So obviousness is knowledge at the time of invention must not be obvious to a person having ordinary skill in the area. And how it is determined? It is determined by the scope or content of the prior art. Secondly, the obviousness is something which evolves. What do I mean by evolves is that if something that was not obvious 10 days ago has become obvious today, and something which is not known today or new today will become obvious 10 days from now. So as the ordinary level of skill in a technology increases, obviousness also increases. Now, technically, if I talk from a rule of thumb point of view, what a patent examiner tries to find when he searches for obviousness is that he will try to find three documents, D1, D2, and D3, which in parts, D1 describes some part of your invention, D2 describes some part of your invention, and D3 describes some part of invention. And he tries to prove that D1 plus D2 plus D3 is your invention, which any person who has an ordinary skill in the art can envisage and do. So this is how an examiner searches for obviousness, and this is what I mean by obvious. If there is any doubt, please ask. I am again and again saying you will not interact, then it's just a monologue. Okay. Now, enablement is basically what I mean by enablement is that anyone who want to use your invention should be able to do it without undue experimentation, because whatever you are disclosing is going to exist in the public knowledge for perpetuality. So it is expected that whatever that with the help of your draft of the invention, or what the document you are sharing in public, anyone should be able to practice that invention. There should be no tricks and tips. Everything should be well explained in the specification. Definiteness inquiry is that it is not possible that in a single invention you cover everything. You can cover only single one invention on the basis of your claim language. If it is going in multiple directions, then your patent application might be rejected, or the examiner would ask you to restrict your claims in a manner that it leads to a single invention. Finally, the best mode is also to be disclosed, and that best mode is actually how to carry out the claimed invention. In the examples of the specification, you are expected that at the time of filing of application, you will disclose the best way in which your invention could be practiced. And this will allow a person skilled in the art to practice your invention. Now, as far as patentability is concerned, I talked about patentable subject matter. Now, there are certain exceptions to patentability. There are a lot of things which are which are in the negative list of things which can't be patented. In the Indian Patent Act of 1970, as amended in 2005, if you go through, these aspects have been covered in Article 3 and 4 of the Indian Patents Act. It provides a negative list of inventions which can't be patented. If you want to see the details, there are sections A, B, C, D, E, F, G, H, I, J, K, and then you have Article 4. But broadly, it basically covers aspects like inventions against public morality. Like, for example, if I come up with a machine that burns oxygen in the entire area. Now, what could happen with that machine? If a machine of such sort is installed, the life of the people living in that area would be endangered. So such inventions which are against public morality, which are harmful to the human life and plant life and animal life, are not allowed. Then mere discoveries, some natural phenomena which you have observed, can also not be patented. Then you have mathematical and medical practices, because if we do so, it will be very difficult to execute day-to-day course of business, as well as the taking care of the health of the patients. Then evergreening of patents, restrictions on evergreening of patents is a very important and significant feature of the Indian Patents Act. The Article 3D is a very important thing in the Indian Patents Act, and if there are certain law students out here, they would definitely know about it. It basically prevents us, especially in the field of pharma and drug patents, from evergreening. That certain drug, which is a very successful drug, companies try to continually continually reap the fruits by trying to come up with delta new products, and then trying to create a fence of patents, so that no other company, even after the expiry of 20 years, is able to get the benefits of that knowledge coming into public domain. Then things covered by other acts, like, for example, if something is covered by Designs Act, if something is covered by Plant Varieties Protection Act, so Semiconductor Integrated Layouts Act, that those things cannot be patented. Finally, any invention which is related to atomic energy related inventions are also not patentable. And even in defense, you need to have permissions from the government of India if you want to have a patent in that. So these are the exceptions. If you want to go into detail, there is an entire list which you can see from the internet. Now, I gave a very good example of what is novelty and obviousness in terms of words. Again, here if you see, I have shown two tables. One is the prior art, or what I mean by prior art is the general knowledge of the world. It is a table with 4 legs and a square top. Now, a new person came up with a new invention wherein he has replaced the square top with a circular top. Now, he has claimed that he has come up with the first ever circular top table. It is new and useful. So, naturally, it is new because the world already knew about a table with a square top. So, as I told you, it is novel. But does it have an inventive step? No. Why? Because for a person skilled in the art, in this case, who will be person skilled in the art? He will be a carpenter. So a carpenter, like our mother, can make a chapati of any shape. He also can make a table with a top of any shape. So the invention is obvious, although it is noble, but the invention is obvious and it would not fulfill the criteria of inventive step, and it would not be patentable. Now again, I come up with another invention. Here if you see, again there is a square top like the prior art. This was my prior art. Is a square top, but 4 legs have been replaced with a single leg having 4 flanges. So is this invention noble? Why? Yes, it is noble because it has 4 legs is not there in the present invention. Again, is the invention obvious? No, because it is not obvious for a person who has ordinary skill in the art to replace 4 legs with 1 leg. So this particular invention, if I consider only the prior art one, which I discussed, the square top with 4 legs, this has a novelty, it has an inventive step as well as industrial application. Now again, I came up with another invention 3. This is again a table with a circular top and a single leg. So if you go into the novelty, you will see both aspects. The circular top is novel in light of the prior art 1. The circular top is novel as well as a single leg with 4 flanges is also novel. However, the inventive step here also will be that it is not inventive step part is only the replacement of 4 legs with a single leg. Now, suppose I introduce another prior art. Now you see I have introduced a second prior art. Here we have a chair with 1 leg and 4 flanges. Now for a second you forget the prior art 1 and see whether in the light of this prior art 2, your inventions 1 and 2 are novel. Yes, still they are novel. Why? Because applications are different. This is meant for sitting, that is meant for keeping things. Now, but if I consider both prior art 1 and 2, prior art 1 was a table with 4 legs and a square top, and prior art 2 is a chair with a single leg. Now, in light of both these prior arts, the invention or present invention, a table with a circular top and 4 flange legs, becomes obvious for a person skilled in the art, and hence this invention will not be patentable. Now I would like to show you some of examples of famous patents related to toys. One, can you recognize this toy? Can anybody recognize this toy? Okay friends, this is a fidget spinner, and this is how the claim of this fidget spinner was: a spatial logical toy assembled from a plurality of toy elements, of which a predetermined number may be rotated in the directions of spatial axis starting from the geometrical center of the logical toy. Another very good example is the Monopoly board game. So this Monopoly board game was again a very famous thing that happened in US. However, you might be surprised to know that when Monopoly was patented, it came to the light of the owners that freedom to operate was not ensured, because Monopoly as a game was violating many intellectual properties. So the company which bought the rights for Monopoly from Charles Diderot had to buy other related patents and copyrights to achieve freedom to operate in the market. However, the game was so famous, the game became such a hit that even today Monopoly is being sold. Then this invention is again it was meant for surgical and other purposes too, but it has become a very famous toy recently during Holi. You all might have used it. These are multiple balloons that fill up in a single go. So the title of the patent was System and Method for Filling Containers with Fluid, and these rubbers acts as barriers for leakage of fluid once a sufficient quality of fuel has gone into these bags, or for that matter the balloons. Now again, doll construction was a patent in US by J.W. Ryan, and it was filed in 1959. And even today Barbie is a very famous toy, and even the young girls, they love Barbie like anything. They sleep with her, they keep her in every moment, and so on. And the patenting aspects of this doll were the articulated relationship. These hands and legs can be moved, so it becomes a lively doll. Now this is the patent process timeline in India. If you draft a specification, you can file a patent, and once after 18 months your patent is published in the patent office journal. You however, with the optional fee, you can also get it published immediately. Then within 42 months you have to file the request for examination, and the maximum time to file a request for examination is 48 months. Then and this is optional. You can file and forget. You don't want any rights, you just want to have a resume patent, you file and get a number, and that's it. But if you file a FER, your patent will be examined, and within 54 months your patent is granted. However, kindly remember that your rights, the T0 for your rights is when you file or the date of application. Even after 5 years, if you find, and if you have definite knowledge, if you have data that someone is using or misusing your patent right from day one, when you file an application for it, you can sue him at that moment, and the courts will get you damages right from the day when he started misusing it. And those damages are so huge at times that the companies are locked down. Now, as I told that a patent gives you only a local protection, so you can go for a global protection. However, for that you need to go through a different route. There are three mechanisms. One is the Paris Convention, second is the Patent Cooperation Treaty, and third is the national phase. Paris Convention is basically an agglomeration of many countries that have vowed to support each other in the intellectual property domain. And under Paris Convention, if I want to file an application in Russia, in Germany, after filing an application in India, I can file it within 12 months with the using the priority of Indian application, and then I can enter the national phase in Germany later. Patent Cooperation Treaty is basically a platform provided by the BIPO, and I think initially only 12 countries were member of PCT, but now almost 163 countries are member of PCT, and this is usually mistermed as the world patent, but it is not a patent as such. It just gives you an extra time. As you can see on the timeline, you file a local application. For example, in our case, we will file an Indian application. We will go for a PCT application within after 12 months of the filing of the Indian application, and then We have time up to 30 months to decide which all countries have a commercial potential and have good enforcement of IP rights for your informal knowledge which you want to protect, and then can decide in which countries you want to enter the national phase. However, your invention is published in the patent office in the PCT journal, which is being looked upon by major countries around the world, and you get a big platform. And if your invention has a good potential, during that period of 30 months you will get a lot of inquiries from those companies, and basis those inquiries you can decide in which geographies you want to protect your invention. Now, as we are approaching the scheduled time, I think I will quickly go through some of the things and will apprise you. So copyrights, as I told you, is about artistic and literary works. These includes databases and computer programs, multimedia products. The most interesting thing about copyright is that you do not need a registration mandatorily for it. The moment you create some artistic or literary work, record it, it is your IP. But if you want a faster legal resolution in case someone violates it, it's better to get a copyright and registered. And with this registration, which is very cheap, around 500 rupees is the expenditure, you can have a IP right for yourself. Again, since it's an expression, it is not about protection of idea. The duration of copyright is sufficient. In case of individual authors, it is life of the author plus 50 years. In fact, in India, it is life of the author plus 60 years. This is the minimum period mandated in TRIPS. Now, in case of copyright, patent is about economic rights because it is an industrial property. In case of copyrights, you have two types of rights. One is the economic rights and the other is the moral right. Now, the beauty of copyrights is that your moral right is always with you. Someone buys out your economic right does not mean that he can market your work in his name. He has to tell that this belongs to Gulshan Kumar or Shashi Kapoor or Javed Akhtar, although he might have those economic rights on it. So India is a member of the Berne Convention. 1957, we came up with an amendment in 1999 to become TRIPS compliant, and legal remedies with minimum mandatory punishment of offences are available in India. So for protection of copyright, you have an online portal called copyright.gov.in. Structurally, copyright has changed a lot. Previously, it was with the Ministry of HRD. I will discuss in the later presentation. Now, trademark is a sign that is used to distinguish the goods and services offered by one from another. The two main characteristics of trademark are that it should be distinctive and should not be deceptive. It should be different and it should have its own appeal for that instance. That is it. A trademark is a sign that individualizes the goods of a given enterprise and distinguishes them from the goods of its competitors. And you might be very happy to know that it's not about trademark is not about just marks, physical marks. It can be sound marks, it can be smell marks, it can be trade dress. Means even if I don't write the name of the shop, the setting of the shop, the color combination of the shop will indicate that it's a McDonald's. You might have seen it. Then as I discussed, the GI is a new term in place of appellations of origin. These are perpetual collective rights, means there is no time duration for having a geographical indication. They belong to the communities, and there is two level of protection. One is just about the product from a particular region, and other is for wines and spirits. Then India had no law previously, and with the TRIPS compliance thing, India came up with a sui generis legislation, the GI Act of 1999. Now, industrial design is another very important right for engineers and for persons who want to join the industry. So these are basically things which appeal your bare eye. However, there are certain areas of overlap between the copyright law and the design law. But the basic thing is that if you want to produce something using an industrial process, you will go for an industrial design, because copyright is about individual pieces. Minimum duration of protection is 10 years, which can further be extended up to 5 years. So you might be able to understand why after every 3-4 years naya RIN comes in, and RIN with a new packet comes in, because its design is going to expire in some days. You have civil remedies for infringement of industrial designs. Another interesting thing is plant varieties protection. Plant varieties is about new plants, new varieties. These are intellectual property rights given to plant breeders, researchers, and farmers who have developed any new or extant plant varieties can also be registered, which are well known, and registration is available for all of them. The criteria that is used for registration is DUS testing: distinctness, uniformity, and suitability. Then the period of protection varies from 15 to 18 years. For 15 years it is for crops, 18 years it is for trees. I think I should move through this slide. Is about IP administration in India. Basically, for all the IPRs I have talked about, there are either specific acts which has been made, or earlier acts which were existing were amended. So these are the various acts, and most of the IPs, patent, trademark, design, and GI, they are all with the Controller General of Patents in Ministry of Commerce and Industry. In fact, with the amendment of 2012 in the Copyright Act, this copyright registration has also come to the CGPI. And then you have this Plant Varieties and Protect Farmers Rights Act. The implementation of this particular act is with Department of Agriculture and Cooperation. And then you have the Competition Act to have a tool against those cartelization, guild formation, and that is with the Ministry of Corporate Affairs. These are the various acts in the domain of IP. These are the offices of IP India and various registries. I think you might be aware, but then you have basically online portals available as on date, through which you can log in and then file the patent applications. You have to complete the formative and substantive requirements through online. Even the fee is lower, to the tune of 10% for online applications, and it is being promoted. This is one scheme. If some of the students want to come up with their own startup, and those startup wants some protection of IP, then the government of India has come up with a scheme wherein it will help those IP seekers with the legal support, and that the fees for that legal support will be paid by the government of India or IP India. This scheme is effective up to 31st March 2023. Now in CSIO, what we do is we have a IPR cell in the laboratory which does processing and analysis of IP applications. Basically, we do patents in the domain of engineering patents, as well as some designs and copyrights, and we coordinate with two units. One is the Innovation Protection Unit at CSIR headquarters, and there is unit URDIP Pune, which specializes in patentability analysis, FTO analysis, and so on. So IPO is about filing and maintenance of IP portfolio of CSIR, and unit for research and development of information products is about patentability search analysis. As I told you, having a patent does not mean freedom to operate, so they also do freedom to operate studies and landscape mapping. If you have heard about this company Green Gold Animation, so this is one company which has effectively used IP as a tool, and as emerging, and has created many characters like Krishna, Chota Bheem, and Bal Bheem, and so on. And they have several business verticals. If you see 2D animation, 3D animation, licensing, merchandising, these are all copyrights additionals. Movie distribution, then you have digital businesses, apps and games, retail stores they have opened up, events they hold, and so on. So it's a IP bundle. Any company that strategizes IP comes up with a bundle and is hugely benefited by it. Now these are some of the interesting keywords in this domain which I usually wish to discuss at the end of all my classes, and which gives you a good insight of the entire domain. One important keyword in the realm of IP is national treatment. What I mean by national treatment is, I always prelude it with an example always, that whenever you go to any archaeological site, Taj Mahal for that instance, you find that the ticket for Indians is rupees 50, whereas for foreigners it's rupees 500. That difference is not allowed in the domain of IP. National treatment is means the treatment which you give to your citizens is available to the citizens of the other countries. So if a regulatory fees is 2000 for an Indian citizen, it is same for a foreign citizen also. Independence of application and patent highway. I told you that every patent application is granted by the patent office of that country and has territorial jurisdiction of only on the within the boundaries of that country. Now I suppose I want a patent of my application in 10 countries. So in each and every country, my application is an independent application. It will be examined independently by that country, and the basis of the search report of the examiner of that company, the country, I will get or not get a patent. So it can happen that if I file a patent in 10 countries, I might get it in 5 countries, and my patent might be rejected in 5 countries. It can happen because the search has its limitation. However, certain advanced countries like Japan, USA, China has teamed up to share the search reports, and that is called patent highway. These shared search reports basically help the examiners, and they reduce their search cost. However, independence of application still exists. The examiner might use those search reports, but he has to see the application independently in the light of the local laws and rules. Then there is a concept of called most favored nation. The concept is that if two countries are friendly, for example, we are very friendly with Bangladesh and we want to give certain privileges to Bangladesh. Under the TRIPS, all privileges given to any country are allowed. Nobody will bar you from extending any privileges. India can extend any privileges to Bangladesh. But the point here is that in that case, those privileges automatically apply to all the other countries. Means everyone is a most favored nation. Another thing, there is no thing notion called world patent. It's a false notion. The only thing which we understand as world patent is usually the PCT application. So PCT application does not give you any patent right. It just gives you 30 months, extra 18 months after filing in the country, to have a global audience to look through your invention with a priority date which is prior to the filing. And so if they solicit some interest, you can take judicious decisions regarding filing in a country or not. Then a very good example is about Basmati patent. In US, what happened was they came up with a new variety of rice called Textmati, and that Textmati had certain claims. But the problem for Basmati was that one of the claims of Textmati was about aroma, and that claim basically, if accepted, would have made Basmati infringing Textmati. So this was a huge problem for India and Pakistan because we are a major Basmati exporting countries. So the Indian government fought the case with the help of CSIR in US, and what happened was Textmati patent might be available even today, but those claims of the Textmati patent which made Basmati infringing Textmati were removed on the objections by the Indian government regarding the aroma. So now Basmati can be exported, although Textmati as a variety is still patented in US. Then another patent was Haldi patent. So Haldi patent, the case was that an Indian in America basically registered the medicinal properties of Haldi. The problem for India was that many Ayurvedic products which are being exported to US would have started infringing that particular patent if it was not fought. So Indian government, on behalf of Indian government, CSIR fought the case and proved that the medicinal properties are well known in India. But they want documentation, and you will be amazed that we had no Hindi documents available of older times which detailed the medicinal properties for the Persian document was found, and that was cited as an example. Then there is a provision called compulsory licensing. These days we all might are saying a lot of medicines are in short supply due to the pandemic. Now compulsory license is a mechanism whereby a patented drug can be allowed to be produced by other producers on the payment of a fixed royalty decided by the patent office of the country, if it is proved that the company which is holding the patent is unable to supply or produce sufficient amount of that material to meet the need of the country, and the life of the pupil is under danger. In that scenario, the compulsory license can be issued by the patent office. Now, finally, if you are in the domain of electronics and telecommunications, you might have heard about 1G, 2G, 3G, 4G, and you are expecting 5G telephony these days. Actually, these 1G, 2G, 3G, 4G is not a single set of technology. It is a bundle of technology, and that bundle of technology is lot of patented technologies, and those patented technologies are belongs to the various private companies and corporations. Now, with SEP and friend licensing practice, what happens is that any country where that generation of technology is introduced, all the companies who want to or who wish to work in that domain are allowed to have licenses for those patents at a predetermined price, which is not very high. That is nominal price, and licenses are not subjective to decisions. They are freely available to anyone and everyone who wants to have that license. So this is how telecommunication industry works with the help of these SEPs and friend licensing terms. Thank you for your attention. I think I have told sufficient. If there is some doubt, I would be very happy, because that indicates how much you have absorbed. Thank you.
Thank you so much, sir, for guiding in a very simple way that what patents are and what are the different forms of IPR. I suppose one of the students raised the hand during the presentation. Is Navjot available? Navjot from agriculture. You want to ask something? Any of the student, if you want to ask something, or any faculty member, it's open for all of you. Sir, I have one sort of query. We say
Mhm.
that geographical indicators are there. This is one of the form of the patent, sorry, IPR. I
Yeah.
just want to know, suppose, Punjab has many things that are very particular to the state. And
Mhm.
if we talk about any particular district, it will be also included in that particular area, or it will be for the state only?
No, no. It is a collective right which is available for a particular area. For example, if there is some Fulkari sort of art which is specific to a particular area in Muxar.
Yeah,
For example, Chanderi saris. Chanderi is a
yeah,
very small place in MP. So
yeah, yeah,
Chanderi saris, what was happening previously was that since the Chanderi people have earned that reputation in hundreds of years.
yeah,
Okay,
yes,
but what was happening that all the power looms in Surat were producing Chanderi saris, and the local people who created that brand or reputation was starving. So with this GI coming in place, a collective framework coming in place, only those weavers who live in the Chanderi area of MP can tag their saris as Chanderi saris. Nobody else in Surat can produce and manufacture saris and sell them with a tagging called Chanderi saris. This is how, at the community level, all the weavers in that region are benefited. In fact, there are certain earnings from it also, and they are at the community level, and those development commissioners of the states are involved actually, and they ensure in a lot of funding into the capacity building things also, because it has a reputation angle also. So this is how it works. It is to a particular region which is famous for a particular thing. It has nothing to do with the state.
Okay, sir. And is the procedure is the same or it was somewhat different from that we file for patent or copyright?
Collective marks cannot be filed by individuals. They are filed through government channels. Most probably, as far as I know, through development commissioners of the state, who ensure that it is registered only for specific and whomsoever is the actual collective owner of that right.
Okay. Thank you, sir. Thank you so much. Any of the student or the research scholar, even the students from law, if you want to ask something, you are free to ask it. May I request Honorable Vice Chancellor Ma'am to say a few words?